right, how you doing? My name is Ali Talai. I'm a trust and estate planning attorney. I have an office here in Woodland Hills, California. And today in this video, I want to talk to you about probate. Is this what your loved ones deserve? And unless you don't like them, they don't deserve probate. And I'll tell you why. But before I go sort of into the actual presentation, let me tell you a little bit more about myself. As I mentioned, my name is Ali Talai. I'm an attorney. I also have an advanced tax degree that allows me to be able to provide more customized tax planning, estate tax planning, asset protection planning for the clients that work with us. I also do a weekly radio show on 670 AM. It is in Farsi, no subtitles. So if you speak Farsi, please tune in. If not, I have daily contents that are published in our YouTube and LinkedIn and all the social media. And it would be great if you connect with us there, give you some information on the next slide. I also have a real estate broker license and a mortgage broker license. I do not practice that, and I do not do anything related to real estate brokerage or mortgage, but it really helped us essentially, particularly because we work with a lot of real estate investors and enable us to be able to provide them with some better legal sort of services and understand their needs and what needs to be done in their field. As I mentioned, if you're thinking you just need to hear more from me and my firm, please subscribe to our YouTube channel, Instagram, LinkedIn, and a lot of the social media platforms. All right, let's get started. You have worked hard. Ensure that you are protecting your life savings, yourself and your loved ones with an estate plan. An estate plan could mean a lot of things. As you know, estate, it's really just all your assets. It's the car, it's the bank account, it's the home, everything else. And then plan, it's plan. And now when we talk about estate planning, it's really we're doing some sort of planning for your assets. And there are different ways you could go about putting this estate plan together. There are some options that we could consider them an option, but most likely are not the best option. And we'll talk about what might be a better way in most cases and scenarios as far as how to do an estate plan. Before we talk about how to do an estate plan, let's talk about what probate is. And reality of it is that probate is a legal process. It's a way, it's a mean that allows for the asset of the deceased spouse or the deceased person to pass to the next person. If they have a will, it'll be whoever they have named in their will. If they don't, then it'll be based on the intestacy laws of every state. California has them as well. So it really just provides a way to transfer these things. And we'll talk about what sort of assets are subject to probate. And this probate process, it appoints a trusted individual. The court appoints an executor, personal representative, sometimes they call them administrator of the state, and really gives them the legal power to be able to do things that are needed within the state. And then, winds up the affairs and does what needs to be, pays what needs to be paid, and transfers the assets to the loved ones. When do your loved ones have to go through probate? So just because I don't have a trust, it doesn't mean if I pass away, there would have to be a probate. It really depends on the type of assets I have and what sort of planning I have done or the lack of planning I have. It's usually if you have some sort of asset that is under your name only. In most cases, that is your home. That is a stock in a small business corporation that you have. It could be an LLC membership interest, partnership interest. It could be assets that are payable to your estate at death. Sometimes life insurance, retirement accounts. If the beneficiary designation form has not been completed correctly, it will say that the amount is payable to the state. And if that's the case, unfortunately, in order for the heirs to be able to receive the proceeds, there would be a need to have for a probate proceeding to take place. Sometimes there's no beneficiary designation. It's missing, doesn't have anybody. So those are really times or events that in order for the assets to move on and transfer to the next generation or the next heir, it would be required for us to have a probate done. Talking about probate, before I go to the next slide, one of the big thing probate does is that it gives this person, that executor, that personal representative, that trusted person, a power to sign on behalf of the person who passed away. And let me give you an example. For example, I have a house and I decide to sell it to you. You seem to be a good person. I want to transfer my property to you. And it could be a sale, it could be a gift, it really doesn't matter. The reality is the instrument that is used is a deed that transfers the property from one person to the next. Sale or a gift, it doesn't matter. If I'm obviously alive, then I will just sign the deed saying, I, the grantor, hereby grant this property to, so and so. And then I sign it. However, when I am not here, when I have passed away, I would not have the power to sign anymore. And so this transfer document that needs to be executed does not have, the person to be, that there's no, person has passed away, we can't have anybody sign there. And what the court does, that personal representative gets the power to be able to sign on behalf of the deceased person. And now that deed could be drafted and it could say the property is going from the state, from the person that passed away to the kids, and it's executed, recorded, and now the property is transferred. So one of the big things that probate does, it selects this person and gives them authority, validates them, and allows them to be able to conduct business on behalf of the state. If you're finding this kind of videos interesting, I ask you to share maybe with a friend or family member who's also in the midst of figuring out what sort of estate planning they need and how it should be put together. I really appreciate if you share the video with them. So let's talk about why would you want to avoid probate. There's really three big reasons. And one is the entire process is public, meaning that anybody could go to court and find out what you had, who you're giving it to, when they're going to get it, how they're going to get it, all that stuff. So there's really no privacy when we're talking about probate. And it can take a long time. Even now that COVID has sort of subsided, it still takes a long time for a probate process to sort of from beginning to the end. I would say somewhere about a year would be an average time. In most cases in our office, we get to see our average being longer than a year, maybe a year and 4 months, 5 months. So it definitely takes a long time for the entire process to be taken care of. And it can be very expensive, depending on what the value of the state is. But California has statutory fees associated with probate, and these fees are based on the gross value of the state. So if I have $1 million home, I don't do any planning, and unfortunately I pass away, there would have to be a probate, and the probate fee is based on the gross value of the property. $1 million is based on the $1 million. The fact that I owe supposedly $800,000 on the property means absolutely nothing. They are going to still figure out the fee based on the $1 million. And the probate fee in California, minimum statutory fee, is about $46,000. So it can get pretty expensive with probate in the process that has to go through. And if you listen just now, I mentioned this is the statutory minimum fee. In many cases, the fee is actually higher than that. So ideally, we want to try to do something that we save our loved ones from the process of probate. All right, so you may think, well, could there be times that we do want our estate to go through probate? I had to think about this for a little bit, but I was able to come up with a few different examples. One is obviously going through the court process is a much, trustworthy procedure. If I don't have anybody that I trust, I'm worried about maybe whoever I select may not do what I want them to do. Then having the process of going through the court proceeding gives me the insurance that I know that my will or my desires would actually take place. It provides a way for the judge, for the court to validate my will and enforce my will if I have one, and then ensures that debts are paid, taxes are paid, and also the court makes sure everybody behaves as they're supposed to behave. So those could be some advantage of having to use the probate process. And then let's talk about how you could avoid being, how can probate be avoided? I can't read. Well, one way to do it is you want to make sure when you pass away, you don't have anything under your own name. The thing with probate, as we mentioned, if the person passes away and they have assets and they own properties and different things that is under their personal name, there's nobody else is on the title, nobody else is with them, then it's at that point, in most cases, you're going to need to go to probate. But if you've done some sort of estate plan that now there's no ownership under your name, there's no probate when you pass away. And sometimes you could use beneficiary designation forms, paid on death transfers, and transfer on death deeds, and those sort of things. So there are certain documents depending on the type of account you own. For example, life insurance, they have this beneficiary designation form. IRA accounts, 401k accounts, bank accounts have these paid on death, PODs, that could be completed. And within those documents, you could name somebody to be the recipient of that account. It could be a faster way maybe to do some estate planning, but usually these kind of planning have their own problems, and we'll talk about those. All right, so probate avoidance tools. We could do outright gifts, designations, joint ownership, or we could do a trust, and we'll talk about a revocable living trust, and I'll tell you how that can help. Outright gift, really easy to do, not a whole lot of legal fees. And realistically, what you're doing, you're giving away the property or the asset during your lifetime, whoever you want to do, whoever you want to give the property to. And it could be used for many things, most things that we have. And I guess the pros is that you could avoid probate if you pass away. And the problem is that you don't have the asset anymore. So if you need the asset, if it's a home you live in, if it's a bank account that you use the funds in there, then that becomes problematic because you don't have the ability to use it anymore. And then when it goes outright to your child or whoever the recipient is, it could be exposed to their creditors because it's going under their personal name. And also keep in mind, when you make gifts, there could be some gift tax issues depending on what the value of the gift is, depending on if you have used your lifetime gift tax exclusion or not, or exemption. And so that's something else to keep in mind. Sometimes when you make a gift, then you're required to file a tax return. They call these a 709 tax returns. All right, beneficiary designation forms. That's another way to be able to transfer and do some estate planning. And we talked about that. And that's mainly just naming somebody in the form as the recipient of the assets. It's simple. You could change it during your lifetime. But again, the problem is that it goes to the beneficiary outright, and it could be exposed to their creditors. The other thing is, if your beneficiary is younger, if I have a child that is less than 18 years old and I name him as my life insurance beneficiary, and let's say I pass away, even if their name in this beneficiary designation form, the life insurance company, for example, still won't give him any money. They would have to be a legal guardian appointed to be able to account and take possession of the funds. So then it creates more problem. The other problem is that the person I name, maybe they pass away before I do. And now we sort of have issues again with the account. Again, some of these initial planning that I'm telling you about, it's a way, it's something you could do, but in most cases, it's probably not the best way. And there are better ways to go about doing these sort of estate plannings. Paid on death designation, same thing. Bank accounts could be done the same way. It's fast, it's simple. However, it's exposed to the beneficiary's creditor. And then same thing, if they pass away, we'll have some issues there. Joint tenancy with right of survivorships. And you get to see this more often on real estate. So two people own properties, they decide that they're going to have it under joint tenancy with right of survivorship. And what this means is that at the time the first owner passes away, his or her share automatically goes to the other spouse or to the other partner who they have held this property with. With joint tenancy, you could have this property, you could, let's say, we'll talk about real estate. Let's say you purchase a property with your brother, you can have the property under joint tenancy. There's no requirement that the partners or the people involved have to be spouses or have to be married, as opposed to community property with right of survivorship, which we'll talk about shortly as well. But so it could be two people. Obviously, you still need you at least need two people to create a joint tenancy, but you could have 10 people all together at joint tenancy. And all it means is that when that person passes away, when one of the people in the joint tenancy passes away, his or her share is divided amongst the other owners in equal shares. There's no probate. However, there at some point, when the last person passes away, there'll be probate. There's some paperwork that have to be filed. There's an affidavit of death of joint tenant that gets filed to reflect that the person has passed away. Again, it could be easy. Transfers are automatic. There's no probate. The problem with it is, a lot of times I see this with parents. They put their daughter, their son's name on their house, and their idea is that, when I, the dad, pass away, my house would automatically go to my son, and so he doesn't have to go to probate. The problem is when I add my son to the deed, now he's considered part owner of the property. So now if he gets in a car accident, somebody sues him, they could have a lien on the property. If I decide that I want to sell the property, I have to get his okay. And if he's married, I got to get his spouse's okay. If I want to get a mortgage on the property, I got to get his okay. And then I got to get his spouse's okay. And so you can see there's lots of other problems usually with these sort of planning that comes about. And again, if I'm making a lifetime gift to somebody, I may have to file a gift tax return, a 709 gift tax return. And for capital gain purposes, again, lifetime gifts are usually not the best idea. Let's talk about community property with right of survivorship. There's actually two vestings. So this community property with right of survivorship, there is this community property that you see, and then sometimes you see this community property with right of survivorship. This community property with right of survivorship, this is actually a new version of community property, very similar to the joint tenancy with right of survivorship. And it became effective and it became law in California in 2001. So there's been numerous times I've seen deeds that have been drafted and signed before 2001, and it just says husband and wife as community property. I've seen deeds past 2001 and it says the same thing. It says husband and wife community property. And the great distinction between them is that if it says husband and wife community property, it means when one spouse passes away, his or her share does not automatically pass to the other spouse. It will require a probate proceeding to get that spouse's share transferred to the surviving spouse. Versus this community property with right of survivorship, this allows this automatic transfer to the surviving spouse without a court involvement. There still would have to be an affidavit of death of community property owner filed, but it's relatively easy, no court proceeding. So if you are going to take title into a property, you definitely wanted to make sure if you're married to the person, you definitely want to make sure you take it as community property right of survivorship. If you're not doing a trust, we'll talk about that on the next slide. Obviously, I think doing a trust would be a much better way to put this sort of estate plan together for obvious reasons. We talked about the pros and the cons, I think. I talked about so many things I don't remember, but it's easy to put together. And unfortunately, at some point when the surviving spouse, when the first spouse dies, yeah, there's no probate, but when the second spouse passes away, you're back to probate if you haven't done really, a more comprehensive plan. All right, so let's talk about a trust, a revocable living trust. We talked about if a person owns nothing and they pass away, there's no probate, or if they have nothing under their name, there's no probate. This revocable living trust or a trust really does the same thing, because how the structure is put together is that you create the trust, then you take your home, you transfer it into the trust. So now the house used to be under my name. Now the house is under, for example, ABC Trust. I'm not the owner anymore. Two things. When I die, my trust doesn't die. My trust is still alive, and it could be alive for many, many years. The second thing that these trusts have that avoid going to probate is that, unlike a will that will require the court to appoint somebody to have legal power to sign on behalf of the state, a trust has a trustee, and that's the person that manages the trust. And that trustee has the legal power to sign. We don't need to go to court to get the court to give this trustee the authority to sign. So in these trusts, they usually have trustees, and then they have successor trustees. So if I create a trust, I could name my son as the successor trustee. When I pass away, the trust's still alive. No death happened to the trust. The trust has a person in it that could exercise the managing power and be able to transfer property, sell property, whatever it's needed to be done. And that's really the reason, and that's how we get to avoid probate, by using a trust. You create the trust, you're the person creating it, you put your properties in there. It could be, the assets could be managed for yourself, for your benefit, and after you pass away, it'll be for your beneficiaries. It's very easy. I mean, a little bit, I guess it's not as easy as doing nothing or some of the other stuff, but relatively, it's not too difficult to set one of these things up. With anything that we do new, sometimes there's certain things that we just don't know, so we're a little bit uncomfortable, but after some times you figure out it's really not that big of a deal. You could do everything that you were able to do before. So if you have properties, rental properties, investment, and all that stuff, and we transfer everything to this revocable living trust, whatever you were able to do before, you could do now. If you wanted to do a 1031 exchange, you could do a 1031 exchange on your investment property that is now in this revocable living trust. If you want to lease your property, you could do the same thing. All the deductions that you were getting, you get to take them as if they were not in the trust. I mean, it's such a way that if for some reason you forget to tell your accountant that you have done a revocable living trust and you transferred your assets in there, it really doesn't make any difference, because he or she does not file any different form or anything because of the fact that this property or the assets have been transferred into the trust. Cons, maybe a little bit higher cost to set them up, but reality of it is if you do have a trust, we get to avoid probate. And if we get to avoid probate, we don't have to pay probate fees. And not that I'm saying there's no fees with the revocable trust or a trust when the person passes away, there's still some administrative work that needs to be done, but it's usually much less than what the fee would be if it was going to go through probate. All right, let me show you a little chart, show you a happy face here. So these trusts, they have really three main roles within them. You have this grantor person. This is the person that creates the trust. And just to mess with us, they have four different names for the person that creates the trust. First one being the grantor. Then they have this trustor name. trust maker name, and then settlor. So all these 4 different names, they all mean that's the person that created the trust. So you create the trust, you transfer your asset into the trust. In most cases, you get to be the trustee of the trust too. So now the second role within the trust is the trustee, and that's the person that manages the trust. In most cases, people that create the trust are the trustee. If it's a joint trust with your spouse, then both spouses are the trustee. One spouse is not able to serve as the trustee. The surviving spouse is the successor trustee. And then if both spouses have passed away or are unable to serve, then we have the successor trustee that sort of comes in and takes care of what needs to be done within the trust. That's the successor trustee. So you transfer everything into the trust, but you are the beneficiary of the trust. This third role within the trust is or are the beneficiaries. However, with beneficiaries, there are really 2 kinds of beneficiary. There is this beneficiary that is the current beneficiary, and then you got these future beneficiaries. We set up the trust, we say, who do I want the asset to go to? Who are the beneficiary of my trust? We think of usually of our children. And a lot of times people think, that's who the beneficiary is. And they are the beneficiary, but keep in mind, they're not the current beneficiary. They're the future beneficiary. The current beneficiary, it's you, it's your spouse. And so if we go back through the 3 role, you're the person creating the trust. You're the trustee of the trust. You're the beneficiary of the trust. With the revocable living trust, you have the power to revoke it, amend it, change it, do whatever you want to do with it. And because you have all these powers, that's when IRS says, you know what, for tax purposes, for reporting income and those sort of things, I am going to completely ignore the fact that you placed your home in there, ignore the fact that you put your rental property in there, ignore the fact that your LLC is owned by your trust. And there's no additional tax paperwork and things like that. That's how they sort of get into that position of ignoring the trust, because realistically, you're in every position, and they call those kind of trusts a grantor's trust. All right. I wanted to talk about 2 quick things. One is, if you have a revocable living trust, or if you have any trust, and we have these successor trustees, we talked about that because we have trustees, we don't need to go to court. They will have the power to sign on behalf of the trust and all that stuff. Sometimes one of the questions I get asked a lot is that, well, what happens, I name 2 successor trustees, and by the time I pass away, they have both predeceased me, or they both say, we can't serve. If a trust doesn't have trustees, does it become ineffective? Is it now voided because now it doesn't have a trustee? And no, it really doesn't make a difference in the structure of the trust. It's still a valid trust. It just means that they would have to be a trustee appointed. And in most cases, you could have different provisions within the trust enabling different people to select a trustee and appoint a trustee. But worst case scenario, you could always go to the court and ask the court to appoint a trustee to the trust. The other really important thing with revocable living trust is that these kind of trusts, they're essential. We all need them for just initial estate planning. If you have a real estate, if you have minor children, if you have more than $184,500 in your bank account, if you have a business, if you recently got married or got divorced, any of these things would really require you to use a revocable living trust. And when I say require, I really mean it's just a better way to do your estate plan. It allows you to avoid the probate process, allows you to leave more money for your kids because they won't have to pay the higher probate process. It provides incapacity planning. We could do asset protection planning for your children. We could do some estate tax planning at the time the first spouse passes away. We could do estate tax planning for your children when they receive the estate. If you have a child who has a special needs, we could do much better planning. I could go on. So it's just really having a revocable living trust or a trust-based estate planning could be much better. However, if we're concerned about asset protection, I have a lot of clients that are in a type of business. They're just more susceptible to lawsuits. They have a higher net worth. And now what we want to do, we want to incorporate some asset protection planning. One thing that we're not able to do with a revocable living trust is that a revocable living trust will not provide us asset protection for the properties that we put in there. If something happened during our lifetime, we get in some sort of an accident, some sort of trouble, and there's a lawsuit filed against us, the assets that are placed in this trust are susceptible to lawsuits. And the reason is you have the power to revoke everything. You have the power to change the trust. So if we're looking to do asset protection, I'm not saying you're not going to need a revocable trust. The revocable trust is like the foundation of these kind of planning. But what we would end up doing, we would do some additional planning on top of the revocable trust. It could be irrevocable asset protection trust. It could be LLCs, limited liability companies. It could be equity stripping. It could be different ways to be able to incorporate some asset protection within the estate plan. I hope you found this video helpful. If you did, please share this video. Please leave comments for me, and subscribe to our YouTube channel if you're watching this on YouTube. And please give me a call. You could schedule a free call with me on our website, 15-minute free call. We could talk about your estate and your estate planning questions, and then we could set up a longer meeting to have a more meaningful sort of a meeting. All right. I hope you enjoyed this webinar or this video. Thank you.